Ramos Abinido, and our topic is all about the Philippine Rideshare Tenancy Act or Public Act number 4054. This is an act to promote the well-being of tenants in agricultural land devoted to the production of rice and to regulate the relation between them and the lords of said lands and other purposes. This act consists of 29 sections can be divided into 6 parts. When Philippine Commonwealth was established, President Manuel L. Quezon implemented the Rice Share Tenancy Act of 1933. From 1903 to 1938, there was an increase in tenancy rate and land ownership was decreased. The decrease was directly attributed to the tendency toward greater concentration of farms in the hands of fewer individuals and in the rapid increase in the number operated under some form of tenancy. As the tenancy problem grew during the 1930s, opposition broke out in the high tenancy areas. Sakdalista movement founded in 1930s by Benigno Ramos. Benigno Ramos is a high-level government employee, opposed President Manuel L. Quezon and the forthcoming Commonwealth since he felt it would merely strengthen the cacique system. Cacique system is a term that has been used to describe what has been observed as the feudal political system of the Philippines, where in many parts of the country, local leaders remain very strong when warlord-like powers. Benigno Ramos initiated the so-called May 2 uprising. The uprising was participated by more than 60,000 Sakdalis with 69 casualties and 1,000 injured. Salient features of Rice Share Tenancy Act. The purpose of this act was to regulate the share tenancy contract by establishing minimum standards. Primarily, the Philippine Rice Share Tenancy Act provided better tenant-landlord relationship, a 50 to 50 sharing of crop, regulation of interest to 10% per agricultural year, and a safeguard against arbitrary dismissal by the landlord. Rice share contract. A landlord is a natural or juridical person who is the real owner of the land as well as less. Tenant is a farmer or farm laborer who undertakes to work and cultivate land for another. In execution of contract, it must have two witnesses. Each of the two parties retain a copy of the contract and the third copy shall be registered in Municipal Treasurer Office. Registration of tenancy contract. Municipal Treasurer shall keep a record of all contracts made with his jurisdiction to be known as Registry of Tenancy Contract. He shall keep this registry together with a copy of each contract entered therein and make annotation on said registry in connection with the outcome of the particular contract, such as the way some extinguish. However, that the municipal treasurer shall not charge fees for, for registration of said contract, which shall be exempt from documentary stamp tax. Duration of the contract shall last in accordance with the stipulation of the parties. In the absence of any stipulation, it shall be understood to last during one agricultural year. Renewal of contract can be done in writing and registered within 30 days after the expiration of the original period. In case of renewing the contract, without changing the stipulation therein, it is sufficient that the municipal treasurer shall annotate the word renewed in the 3 copies of the contract and in the registry of tenancy contract.
Hello sir, good day to you. So our topic is the Philippine Rights Shared Tenancy Act, Public Act 4054. So my topic is all about the basis of sharing. So the crop shall be divided equally given to the tenant. So when we say tenants, a person who occupies property or land to the landlord. So for example, in a boarding house, when we say boarding house, there's a boarder. So it has the same meaning of the tenants and the boarders, or there's an similarities between the two terms. So shared equally, expenses for planting, harvesting, threshing, irrigations, and fertilizers, well as other incidental expenses for the proper cultivation. So when we say shared equally, there's an equality given to the tenants. There's a equality between the landlord and the tenants. And expenses for planting, harvesting, threshing, irrigations, and fertilizers, as well as other incidental expenses for the proper cultivation. It is very familiar of all words that I say. So there's no elaborate, because it is very understanding. So let's proceed to loan. Loan advances incurred by the tenants shall bear interest not exceeding centum per agricultural. Bear written contract, if not, shall bear no interest. So when we say loan, it is very familiar for us because we are experienced that. So when we say loan, and in my topic, it is exceeding 10% per agricultural. When we say 10% per agricultural, it is 10% of the interest of the loan. For example, I will have loan amount of 20k, so the 10% of that, my interest is 2%. So loans other than money with no interest and excess 10% shall be added to the invoice price. Inflations of the original price shall be finalized according to the usury law. So when we say usury law, are regulations governing amount of interest that can be charged on a loan. So it's all about the interest of the loan. So limit of loan, 50% of the average yearly tenants shall on the particular phase of land allotted to the tenants for cultivations during the last 3 years. So limit of loans, there are 50% of the average every year tenants share on the particular piece of land allotted. So there's an 50% every year tenant share on a piece of land allotted to the tenant. So naibahin ang tenant every year 50%. Imagine katunga. And then for during the last 3 years, Landlord as manager. Landlord as manager, management can be exercised either directly or indirectly through a representative. When we say landlord, she or he managing the property or the land, but they are not the owner. They are just managing, but they are not the owner. They are accommodating the tenants or what the what are the concerns of the tenants. That's it. Thank you.
Good morning, classmates, and good morning, sir. Today I will discuss about the rights and obligation of tenant in the Philippine Rights Shared Tenancy Act. Under the Philippine Rights Shared Tenancy Act, tenant farmers have certain rights and obligations. Here are some of the key rights and obligations of tenant farmers. Rights of tenant farmers. 1. Right to cultivate the land. Tenant farmers have the right to cultivate the land they are leasing from the landowner for agricultural purposes, specifically for rice production. Number 2, right to a fair share of the harvest. Tenant farmers are entitled to receive a fair share of the harvest or produce from the land they cultivate. The specific sharing arrangement should be agreed upon by both parties, but it should not be less favorable to the tenant than the minimum standards set by the law. Number 3. Right of protection against excessive rentals. Tenant farmers have the right to be protected against excessive rentals or charges imposed by the landowner. The law sets limits and the amount that can be charged as rent. Number 4. Right to security of tenure. Tenant farmers have the right to security of tenure, which means they cannot be arbitrarily evicted from the land without just cause and due process. The law provides specific grounds for eviction, such as non-payment of rentals, violation of lease terms, or conversion of the land for non-agricultural purposes. Obligation of tenant farmers. Number 1. Payment of rent. Tenant farmers have the obligation to pay the agreed upon rent to the landowner. The rent can be in the form of a fixed amount or a share of the harvest as agreed upon by both parties. Number 2. Proper cultivation and maintenance of the land. Tenant farmers have the obligation to properly cultivate and maintain the land they are leasing. This includes using appropriate farming techniques, taking care of the crops, and preventing soil erosion or degradation. Number 3. Compliance with lease terms. Tenant farmers are expected to comply with the terms and conditions of the lease agreement, including any specific provision related to farming practices, crop rotation, or land improvement. Number 4. Participation in agricultural cooperatives. Tenant farmers are encouraged to participate in agricultural cooperatives or organizations that promote their welfare and provide support for their agricultural activities. It is important for both the landowner and the tenant farmer to have a clear understanding on the rights and obligations to ensure a harmonious and mutually beneficial relationship. The next topic is about the flaws of Tenancy Act. While the Rights Shared Tenancy Act in the Philippines aim to address the issues faced by tenant farmers and provide them with certain rights and protection, it has been criticized for several flaws. Here are some of the common criticism. 1. Inadequate share for tenant farmers. The law sets minimum standards for the sharing of the harvest between landowners and tenant farmers. However, these standards are often considered insufficient to provide a fair and equitable share to the tenant farmers. The fixed shares specified in the law may not accurately reflect the actual contribution and efforts of the tenant farmers. Number 2, lack of enforcement and monitoring. One of the major flaws of the Rice Shared Tenancy Act is the lack of effective enforcement and monitoring mechanism. Violation of the law, such as charging excessive rentals or unfair eviction, often go unchecked due to the limited resources and weak implementation. Number 3, limited coverage and exclusion. The law primarily focuses on rice production and does not cover other agricultural crops. This exclusion leaves tenant farmers engaged in other types of farming without the same level of protection and benefits. Additionally, the law may not cover all tenant farmers, as it only applies to those engaged in shared tenancy arrangements. Number 4, inadequate support services. The Rice Shared Tenancy Act does not provide sufficient provision for support services and assistance to tenant farmers. Access to credit, modern farming techniques, infrastructure development, and other forms of support are crucial for improving agricultural productivity and the welfare of tenant farmers. Number 5, lack of flexibility. The law's fixed sharing arrangement may not accommodate variation in productivity, input costs, and market conditions. This lack of flexibility can hinder the development of more mutually beneficial agreements between landowners and tenant farmers. Number 6, limited incentives for land improvement. The law does not provide sufficient incentives for tenant farmers to invest in land improvement and long-term agricultural development. This can discourage tenant farmers from making necessary investments and improvements on the land they cultivate. It is important to note that this criticism highlights the need for continuous review and improvement of the Rice Shared Tenancy Act to address the evolving needs and challenges faced by tenant farmers in the Philippines.